appreciate that. That we're working off of LC 460436S. We've made some modifications to that with the Commissioner's Office. And really, this is the simpler of both of the bills. It is basically an annual notification to the policy owners when a policy exists. What under current statute, what we find is that those policies that are paid up and other policies, there's no notice sent to the insured after it was paid up. And so what this does, it just requires an annual statement, just like you do for a checking account or a savings account. It gives you that notification. And that's what we did, and cleaned that up. So that's a real simple bill. Sounds simple. Where it really comes into play is in smaller policies, and I say that we call them debit policies that are under $10,000 or so. They just don't get any attention. And what happened out of this was a real life situation. I had somebody found a policy after 14 years. Her father had been dead. It was bought on her, and it was worth about $8,000, so it was money that was hers that she didn't even know existed. So I think that the annual notice is just a reasonable due diligence to protect our citizens and our policyholders, and that's on SB 112.
Thank you, Mr. Chairman. My name is Vince Lally. I'm on behalf of the Georgia chapter of the National Association of Insurance and Financial Advisors, NAIFA for short. I'll be very brief. We do support this bill. We believe that it helps our insureds and their families, and it also just overall helps the state of Georgia. So thank you, and thank you, Senator Harkin, for bringing it.
Thank you, Mr. Chairman. I move Senate Bill 112 LC 460436S be passed.
Second. Motion and second from Senator Robinson. Any further discussion? Hearing none. All those in favor of Senate Bill 112 be substituted. Raise your hand, keep them up. It's unanimous. All right. Your turn.
Thank you, sir. Thank you, Mr. Chairman. Appreciate that. The second bill, excuse me. Okay, second bill we talked about a little bit in our last meeting, and it is a policy locator bill. And I mentioned this just for those who were here, not here last time. You have the ability to find a policy, and there's a service that's provided by the National Association of Insurance Commissioners. In fact, you will find that link on the Insurance Commissioner's website. The issue for, okay, no. Oh, I'm sorry, excuse me. Sub number, LC 460437S, excuse me. Okay. So we have a locator service that is endorsed and run by the National Association of Insurance Commissioners, but they have no authority over the insurance companies that do business in the state of Georgia. That's really the issue of why we need that. Currently, it's all voluntary. The companies voluntarily search that database. We changed it from quarterly to an annual report issue that we had been asked to do. I wanted to clarify one thing that was said, and I've got a letter here just to, and I'll give copies of that if we need it, is that this came from the Insurance Commissioner's Office. It says currently there's no requirement in Georgia law for life insurance insurers to review the National Association of Insurance Commissioners policy locator. We believe only 4 states currently require this. However, there is a legal requirement under the Unclaimed Life Insurance Benefit Act found in OCG 332514 for life insurers to check the Social Security death master file against other enforced policies on at least a semi-annual basis to identify potential death master files. And so what happens is it compares the death benefit list to that, but there's no requirement to check the locator. And that's where, if you have a policy that's unclaimed, it goes to the state of Georgia. From that standpoint. So that's I guess that's maybe why that's there. But I do have a letter, and I wanted to clarify that from the commissioner. There's also, and I just mentioned this one more, this article is dated April 17th of 2016. This is where everything really kind of started. And I mentioned 60 Minutes did one, but this is where in the state of Florida, with their commissioner involved, there was a $7.5 billion settlement from the life insurance companies. This made a lot of how do I say, press from that standpoint. And it was every major insurer. So that portion, So what this does is requires the companies that operate in Georgia to check that and report back within 90 days back to those people who put in the inquiry. And I think it's a good piece of legislation to help people of Georgia that need to find a life insurance policy.
Okay, thank you. It looks like we've had a technical problem that we fixed now. So, thank you. Any members of the committee have a question for Senator Walker? And since Senator Cowser's not here, we might as well slow things down a little bit because he's got the next two bills. So somebody want to make something up so we can give Senator Walker a hard time since he's had an easy day of it so far? Let's see. Senator Harbin, you're number 8. Go.
Well, with the long list of people who have approved this, I want to know what your wife thought.
That was appropriate a question.
Being in the insurance business, I think and I thank you for bringing this forward. Chairman Walker, because
Yeah,
the only people I could
Just in
see
case
that
you
might
didn't
be in opposition to this bill is Federal Express and UPS and the U.S. Postal System. It does change that, but thank you for bringing it, and I think it makes us more efficient. So thank you for bringing that bill.
All right, I am open for a motion on this unless there's nobody signed up to testify, just to make that clear. I've recognized Senator Kirkpatrick.
So I would like to make a motion to pass for Senate Bill 169. Do you need the LC number?
No substitutes. I think we're good. Okay. Thank you. I have a motion. Is there a second? Senator Merritt's raising her hand. So we have a motion and a second. Any further discussion? Hearing none. All those in favor, please raise their hand and keep them up till we get it counted. Looked unanimous again. Congratulations, Senator Walker. Thank you for your help for Georgia. And we're going to hope that Senator Calzett will be walking in any moment here. Vice Chairman Walker is familiar with this bill, and he's agreed to get started while we're waiting to find Senator Calzert. So we're going to recognize him at this time. Senate Bill 166.
Thank you, Mr. Chairman. Senate Bill 166, LC 364639. I'll do my best to explain my understanding of the bill. I'll ask Vince if he'll, correct me if I say something that's not right, but basically in a civil trial, if it goes to a jury trial, the attorneys, well, there it is.
Go ahead. We will let you, do what you were doing, and Senator Calzert can take a deep breath and then correct you if he hears anything you do wrong.
So in a civil trial, during jury selection, jurors are disqualified under the Georgia Code already if they have a relationship to one of the interested parties. And so one of the types of relationship would be if you are, let's say it's State Farm is the insurance company involved by the defendant or the plaintiff, I guess, and a juror is got their insurance with State Farm or Georgia Farm Bureau. That would be a disqualification from serving on the jury. Currently, those questions are asked in front of all the other jurors, and this bill would change that to be where it would be on a questionnaire instead of in verbally in public, so not to I guess maybe possibly taint the other jurors. And it just seems like a good common sense, easy fixed to issue in court.
Thank you for stepping in, Mr. Chairman. You,
Well presented.
let's see. Let me get your mic on. I can't tell which number that is. It must be 5. Let's try it.
Okay, does that work? All right.
Y'all here?
Very well presented. Chairman Walker, some counties are already doing this. I know I practice in Gwinnett County often, and the prospective jurors, they'll just have them fill out a questionnaire. They served on a jury before, confirming their address and citizenship and different, they've ever been a victim of a crime. The normal questions that are asked, they'll just add the question, who is your automobile insurance with, or your liability coverage with? And it just prevents it from being emphasized in front of the jury panel when the lawyers start asking questions. And the harm there is that if jurors know there's insurance available, and it's not actually being paid any verdict out of the person's pocket, then they're more inclined to grant larger awards. So it's unfair to the defendant in the case, but it's also, you need to protect against these conflicts of interest, so you shouldn't allow a juror serve on a case where their insurance company's involved. So this accomplishes the mission, the goal of preventing conflicts without injecting bias into the jury panel.
Does any member have any question for the bill's offer? Senator Merritt, you're at 10, I think. Okay.
Thank you, Mr. Chairman. Senator Cowser, how confident are you in the effectiveness of people filling out that questionnaire ahead of time?
Well, they'll do it before they're allowed to be questioned by the attorneys. Occasionally you will have some that don't mail it in advance, but before the court system allows them to question, they can fill it out while they're there at the courthouse.
Okay, and that's my concern, is I personally don't have confidence in people filling that out ahead of time. I
Yeah,
know,
You're astute.
I know people just don't, if it doesn't take 2 minutes or 1 minute these days, they just won't do it. And then, can you confirm, would the questionnaire be sworn testimony?
They can have it be if they want to, I don't know. I mean, if you can say that you're swearing it, on the form itself, they can have that provision.
All right, Senator Robertson.
Thank you, Chairman. Chairman, I think in the past, you and I kind of tracked a little. If you look on line 17 and 18, it says, "The court shall exclude any jurors from calls after board hour if the questionnaire reveals."
Senator Robertson, I'm sorry, we're having a lot of technical issues. Can you push your button and then push it down again, and let's see if we can get your mic working? No, it's not. I've cleared them all twice, but nope. Try again.
I got a steady red light now.
Hmm?
I'm gonna get someone to come in and look at this.
I think if anybody can't hear me, if you raise your hand. 17, at the end of 17 and 18, it says, "The court shall exclude any jurors for calls after board hour if the questionnaire reveals a relationship to any insurance company that has a financial interest in the outcome of the case." Now, my homeowners, my auto, and everything is with State Farm. And I've been with Becky Goldsmith for a long time. And if I were, found myself on a civil jury, and one of the drivers of the vehicles happened to be one of her clients, I think my ethics, my character would make me listen to the facts of the case, and in the front of my mind, I would not be thinking about the impact that it would have on my insurance premiums or anything else. And I think in some cases, and the vast majority of my experience testifying has been in criminal cases, but I've seen a lot of cases. Are we getting a little too are we pushing the scales out of balance by giving the court the power to determine what interest is, what financial interest is, and giving the attorneys on either side an opportunity to exclude good, sound jurors from a case?
Well, I guess that's a policy question, but that's already in the law. If you go back up to lines 10 on the first page, 10 through 13.
Right.
We already have, as a matter of law, you may not serve on a jury if you have that relationship with the insurance company that's going to be ultimately held responsible. So I guess we save you the problem of having that ethical quandary by just disqualifying you from the jury.
Right, but that's being done in open board diary, correct? It's not being done via survey, is it?
Right now, it's being done largely in open court. If you read the existing law, which is lines 10 through 13 on page 1, it doesn't say open court or by questionnaire. That's why there are some courts already using the questionnaire, but they must exclude a jury because they are disqualified from serving if they have the same insurance.
Correct.
Or their spouse works for them, or the third degree of relationship.
But what you're doing is you're basically hiding the juror behind the survey, right? Because the only courts I've ever been in where surveys were done were like capital cases, where they would ask particular questions related to capital punishment, things of that nature. The vast majority of voir dire is done in open court so that both attorneys have the opportunity to hear the same information from the individuals presenting that information so they could determine who they wanted on the jury
But here they don't have that choice.
Okay.
As soon as a juror indicated, I've got State Farm insurance, or my wife does, it doesn't matter how they answer the rest of the questions. They're not eligible to serve on that jury.
Okay.
So, in many cases, it is important. Let's say it's a death penalty case, for me to ask you, well, what are your views on that? Would you be opposed to it under any circumstances? Because you are not automatically disqualified from the jury service based on your views of capital punishment. But here you are, and one of my clients is State Farm. So they're a mutual company. State Farm Mutual Automobile Insurance Company. That means if they have a good claims experience this year and they're more profitable in the past, you're going to get a refund because you're one of the owners of the company, so to speak, by being a policyholder. And if the company pays out less in damages, then your premium goes down, or else you get a dividend check back. So you got a financial stake in the interest of whether you're assessing damages against that person or not, which is why you're disqualified. Thank you.
Chairman Kirkpatrick.
I thought I understood this until we started talking.
I guess I'm doing a poor job. Maybe Senator Walker can take over again from here.
Since I've been going to law school and judiciary committee, I just wanted to ask you, I thought the bill says that the jurors would be excluded after voir dire, but you seem to indicate that they would be excluded automatically, so would they then still go through voir dire?
Well, that's currently, voir dire is just the questioning of the jury. It's the jury selection process, and if you ask this question on a questionnaire, then it doesn't have to be asked in that voir dire process. But the reality of the way this would work is if that you say you had State Farm, you would never be subjected to the questioning of any other questions anyway, because you're out of the pool to be selected for that case because of your conflict, we'll call it.
Thank you. Any further questions? We're going to take some public testimony then. I think we've only got one person signed up. Brandon Peak, I think that's what I'm reading there. Please tell us who you represent in addition to your name.
Thank you, Mr. Chairman. My name is Brandon Peak. Would it be okay, Mr. Chairman, if I remove my mask?
Absolutely. Nobody's sitting too close to you, doesn't look like it.
Thank you, Mr. Chairman. My name is Brandon Peak. I'm a lawyer at Butler, Wooten, and Peak Law Firm in Columbus, Georgia. I'm here on behalf of the Georgia Trial Lawyers Association, of which I'm legislative co-chair. So we start with the premise that Senator Calzert and I and all lawyers agree on, which is the purpose of jury selection is to have fair folks on the jury who don't have a financial interest in the outcome of the case. We all agree with that. So the question before this committee here today is how best to do that. Do you do it the way that we've always done it in 159 counties for years and years and years and years, or do we try to change things? And if we change things, are we changing them the right way? So there is a legal problem with this bill, and there are practical problems with the bill. Senator, you asked the question about would the jury questionnaire be under oath? And as exists in the bill right now, the answer to that question is no, it's not under oath. And that's a major problem, because before jurors are impaneled and questioned, OCGA 15-12-132 requires the trial judge to swear in the jurors so that they are telling the truth. And that's an important part of the process. It lets them know this is a serious matter and the questions that they're asked need to be truthful. So the current version of the bill does not specify that it needs to be under oath, and that's a major problem. The other thing that Senator Calzert accurately states is that this would be done outside of the presence of the lawyers. We've all learned from COVID that a lot of our communication is nonverbal, how somebody reacts to a question. And in the real world, this is one of many, many, many questions that either the judge or the lawyers conduct during voir dire, and it's buried. It's one, maybe two questions, we move on. So a legal problem, it is done without oath. And the practical problem is this. There are some large counties like Gwinnett County, which is extremely organized in their jury selection process. There are other counties that are not. And what trial judges hate jury questionnaires, because you have to do it either one of two ways. You either have to mail it out with the summons and have folks hope that they fill it out at home and bring it with them. Well, do they have a computer to print it off? If they don't have a computer, when they get it, are they going to lose it? Are they going to bring it back with them? In my experience, when you send a jury questionnaire out, you know, some jurors accurately fill them out and bring them back complete, and many others do not. It's just hit and miss. There's also a cost of doing that for the counties. You know, I'm on the Muskogee County Access to Justice Committee, where we're trying to get folks to resume jury trials and come up with a plan. And one of the practical matters that we address during that is if you include a bunch of other instructions with the jury summons, it costs more. So we had to include a link to the website that the juror had to go to then look at certain things about what they need to do to show up for a jury trial. So mailing it is not a great option. And I think that you all are discussing that in other matters here before this legislature. The other option is filling it out when they show up. So in larger counties, you're going to have a pool of people who show up. And they may be there for a criminal trial, they may be there for a civil trial. And you don't know ahead of time whether they're going to be pulled for a superior court criminal trial or a state court civil trial. And so you either have to take the time to have them all fill out the questionnaire there while they're in the jury room, or you have to have them brought up to the judge's chambers, courtroom, and then take time to fill out the jury questionnaire there. And so judges hate wasting time doing this. These folks are voters. Most of them all don't want to be there anyway, and they're there to fulfill their civic duty. And the last thing the judge wants to do is have to get pencils and papers and delay things while people try to fill these jury questionnaires out. It's just unnecessary. I mean, it's a lot easier and more efficient just to simply say, is anybody here insured by State Farm Mutual Insurance Company? You raise your hand. Boom. You excuse those jurors and you move on with the trial. I mean, there's no reason and there's no anecdotal evidence that I've seen that this factors into the jury's consideration at all. And I can tell, I'm sure Senator Calzert has focus group cases. And for every person who you have who may think, well, I may give a verdict a little bit larger because an insurance company is involved, you got somebody on the other side who's saying, I don't want to do that because it may raise insurance premiums. We trust people and jurors to do the right thing. You give them a limiting instruction. You tell them, don't take insurance into consideration, the judge gives that at the conclusion of the case, solves the problem. So I understand why Senator Calzert submitted this bill. We respectfully oppose it and believe it's unnecessary, would waste time and judicial resources. I'm happy to answer any questions that any of the committee members have.
Well, thank you. I appreciate you. I thought this was turning into a filibuster for a moment there. Let's see. Anybody have questions for? Let's see. Senator Harbin, you're at 9. Go ahead.
Mr. Chairman, given, what in the bill could be salvaged, or how would you correct it if you were to write this bill, I mean, without destroying it that you can't, or maybe that's what you want to do? I'm just trying to.
Well, it's a solution in search of a problem. We don't believe that there needs to be any change to the bill whatsoever. I mean, to the current state of the law, because it's done efficiently in courtroom. But certainly it would need to include an under oath attestation. Yes. And you're going to have to consider some money to give to these counties who don't have the resources to increase their mail cost to send questionnaires out.
Senator Watson, did you have a question?
Yeah.
Recognize you.
Thank you, Mr. Chairman. I'm not sure my mic's on.
I can hear you, Senator.
That's okay.
Try now.
Testing. I don't think it's working, but I'll try to speak up if that's okay.
Okay.
So, just for my education, and this may be better for the author, so the county is not able to swear it in if this law goes into effect?
Currently, the way things work, Your Honor, Senator I'm a lawyer, I'm sorry. I'm just a senator.
I got you. I'm not looking for a long answer, yes or no, Lisa.
They're sworn in by the judge when they're there in person.
Right, so they can swear them in ahead of time, before they answer any of these questions. Say they handed out pencil and paper, they can swear them in to tell the truth at that time?
Physically, we're talking about having the judge going down to the jury room.
Yeah, I know. Goodness gracious, that is terrible, isn't it? I get it. I've done jury duty a few times, and the judges, they're really pretty aggressive about being nice to the jurors, but I understand. So you can still swear them in. The cost could be pencil and paper. And you're trusting the jurors to tell the truth, which is absolutely the case that they should be, whether they're sworn in or not. And then to do this in an open courtroom versus privately, I mean, that's your biggest concern here from a trial lawyer standpoint? Maybe that's not a question.
Chairman Robertson.
Yes, Mr. Peake, and I'm familiar with the jury pool you're talking about. And while I have a tremendous amount of respect for my friend to the right, my impression of Superior Court judges and how their schedules are timed and how they manage their case dockets are pretty thin. But what's the average size of a pool that where your firm comes in? Because my understanding is you would have to go down and offer this survey to everybody within the pool. The survey would be taken in, and then all the information in the survey would have to be processed by the officers of the court, the attorneys, the judges, or the judge, and then you would start through the voir dire process. Is that what you think this bill says?
Yes, and you have to have at least 24 for a panel for one case. But what typically exists is you have multiple panels for multiple trials, and you don't know which jurors are going where.
That's right. So the question about the insurance, which the summary of the bill is disqualifying jurors from financial interest in cases involving an insurance company. But that would only be one question on this survey, because in typical voir dire, we want to know about relationships between the parties and the possible juror and all these other things, correct?
Yes.
Okay. So even if they show up in person and they're down there in that giant room with all those other citizens. We've got to figure out who's coming up, what surveys they're going to fill out. Then the officers of the court have to digest the information within those surveys, and then we go through voir dire, and at what point the judge swears them in, whether it's, going down, it's just not practical, I don't believe. But so, thank you. You've answered my questions. I appreciate you.
Senator Cowser, thank you. Appreciate you. I'm going to let you close up here, and we're going to move on. We've got another bill to do. So.
All right. I'll address the cost concerns there. I mean, first of all, this isn't an additional mailing cost. You have to mail a summons to the juror so they'll know they're on jury duty to come to court. Include the questionnaire in that. If they fail to fill it out, make them fill it out when they get to court. That's what every court that I'm practicing in now is doing anyway. So it's certainly not an additional mail cost. It's probably cheaper for the county if they're not paying somebody $25 a day to come down there that they know is already disqualified. I do Georgia Farm Bureau work in northeast Georgia. We got a lot of rural type counties that's maybe 50% of the insureds of Georgia Farm Bureau. They call in about twice as many jurors as needed because they know a bunch of them are going to be disqualified in that case. This is just a matter of efficiency. I think you can have an oath in writing, just like live, and if it's insisted that it be live, then just when the judge introduces the jury panel, say, do each of you, swear to tell the truth and everything you've put on your questionnaire truthful. And this is searching for a roadblock for this bill. It's just common sense.
All right. I'm going to recognize you, but let's keep it brief if you don't mind.
Absolutely. So you're amenable to the whole point?
Absolutely. I don't mind that it be just inserted in this bill that the written questionnaire under oath.
All right, the chair is open to a motion at this point. Chairman Walker.
I make a motion we move to pass Senate Bill 166.
We have a motion. Is there a second? Senator Harbin, I recognize you. We're talking about a do pass motion on Senate Bill 166 LC 364639. I'll ask those in favor of the motion, please signify by raising your hand. Y'all keep them up, keep them up, keep them up. 1, 2, 3, 4, 5. The nose like sign. 1, 2.
I would deem that to be a friendly amendment on line 16 after the word questionnaire.
Well, let's get back. I never heard anybody make a motion to do an amendment. So what's the will of the committee? Do you, Mr. Chair?
I think the motion and seconds on the bill as it stands, and so I think that vote is the vote that has to be recorded in the committee, unless the chairman chooses to back up and start the process again.
Okay. All right. We've been advised that amendment is appropriate, and Senator Harbinson, do you want to?
Yes, I make it.
It'd be line 16 after the word questionnaire. Just insert under oath.
Is everybody clear? Adding under oath to line 16 after the word questionnaire and before that. We have a motion. I need a second for that. Senator Kirkpatrick, recognize you. Thank you. So we're, correct me here, how do we, we're going to move to adopt the motion on the amendment. Okay, just make sure everybody knows what they're voting on. Okay, those in favor of the amendment, please raise your hand. 3, 4, 5. Those against, like sign. 2. Okay. Now we are going to move forward on the bill as amended, as a committee substitute. LC 364639. All right, do I hear another motion? Got Senator Watson here, second. Senator Harbin. The motion second. Any further discussion? Hearing none, those in favor of the bill as Senate committee substitute, please raise your hand. Do pass. 1, 2, 3, 4, 5. Those opposed, like sign. 2. All right. The bill passes. Senator Cowsert, let's move on to your next bill.
Okay.
191.
This is, the reason these bills are in the insurance committee is because they so directly deal with insurance. And there are 2 corresponding rules that we want to keep juries from being biased due to the existence of insurance. It works both ways. You've heard the plaintiff's bar. I'm sure Mr. Peake could explain the collateral source rule. If your medical expenses have been paid by a medical insurer, you're not allowed to let the jury know that because it might bias the jury against you as the plaintiff if you know they're really not out of pocket for their medical expenses, and so that is forbidden. Generally speaking, there's a rule of evidence that you may not mention the fact that there is insurance available to the defendant because it biased the jury against the defendant. In fact, you can have a mistrial declared if people voluntarily say, oh yeah, you know, my insurance company said they would pay this claim or whatever. There was an exception created for motor common carriers, and motor common carriers were generally freight carriers, people hauling people or goods for hire. So it was trucking companies essentially, or bus companies or whatnot. If they were from out of state and ended up getting sued, you know, caused a wreck here in Georgia and got sued, we require them either to post bond or to have proof that they have liability insurance available to them. And that was to protect Georgia citizens from getting injured by folks involved in interstate commerce and not being held responsible for it. Well, this has an exception that if it is a motor common carrier, then you may sue that trucking company, let's call it, their driver that was at fault, but also name their insurance company. We'll just use State Farm Mutual as an example, as a party defendant in the case. The reality is that doesn't in any way impact the existence of coverage and that it will apply to pay the loss, but it allowed a direct action against the insurance company. Well, that is also, as you could just imagine, extremely prejudicial to the jury when they know there's an insurance company that's going to have a judgment against it to pay the judgment in the case. Insurance companies always contractually obligated to provide a defense for their insured and to pay the verdict up to the amount of the insurance company that coverage that was purchased. The reason I chose to bring this law is because we did something a few years ago when we changed which government agency was responsible for regulating interstate commerce, and we changed it to the Department of Public Safety, I think, and in that bill we adopted a federal definition of motor common carrier or commercial vehicle, which is much broader than a commercial vehicle for hire like I just described. And so now, theoretically, until we either clarify or clean up this law, some trial court judges are saying, well, if your truck is used in commerce, then your insurance company can be directly sued. Most of the judges that I've practiced before say, no, that was not the intent of the Georgia legislature. And unless it's interstate commerce and you're moving goods or people at the time, then you can't name the company, but it's somewhat ambiguous. So as I looked for ways to solve that problem, it seems that the cleanest way is just don't have a direct action statute against an insurance company. That's going to jack everybody's insurance rates up when you know they're in there, especially if it's used more frequently than intended. Companies are required to have insurance. Our Georgia law requires that. If they fail to have insurance, well, then this wouldn't apply anyway because there's not an insurance company involved to have the direct action against it. Just by definition only applies where you do have insurance that's there to protect the Georgia drivers if they were to get hurt by a negligent person. So this is just an issue of fairness, and I'm sure this committee is aware we've got some of the very highest automobile insurance rates in the country, and this is the type of rules that contributed to that, just like the past bill.
Thank you, Mr. Chairman. Any members have a question for Chairman Calzert? See no hands. Mr. Peak, you want to let us know if you can? We've got a committee meeting in this room coming up, so just be as brief as possible. Thank you.
Mr. Chairman, so we are opposed to this bill. This statute has been on the books in one form or another since 1937, for over 80 years. And the purpose of the statute when it was enacted by this legislature was to protect members of the general public against injuries caused by the negligence of motor carriers. That's what it does. Now, today, Senator Calzert said his real intent behind the bill was to ensure that the definition of motor carrier included motor carriers for hire, but that's not what this bill does. It eliminates the direct action statute in its totality and says that insurance companies cannot be joined in a lawsuit. So why do you join insurance companies? It's actually a separate contractual action against the insurance company. Why do you have this for motor carriers? Because they're transient in nature. Their drivers many times, most of the times, do not even live in Georgia. The companies are not based in Georgia. What happens if they go insolvent? What happens if they go bankrupt? There's no meaningful way for Georgia citizens to redress their injuries. Why is that relevant to commercial motor vehicles? One only needs to look at the Georgia Southern Nurses cases, which I handle, or the recent wreck involving Harrison Deal. The size of motor carriers on the roadway are such that when a wreck happens, the injuries are catastrophic or people die. And so the real question to this committee is whether it's more important to protect the health and welfare of Georgia citizens when they've done nothing wrong and been hurt or killed by a motor carrier or not. That's really your question. That's the legacy of this bill that Senator Calzert authors. And the last thing I'll say here is this is not just limited to tort claims. It also deals with cargo claims. Say I'm a small businessman in Southwest Georgia and my cargo is damaged by the negligence of a motor carrier. Then I don't have to go chasing that motor carrier to Iowa or Kansas in order to get compensated. I can sue the motor carrier directly, and it's limited to the amount of the insurance coverage. And it's a fairly narrow set of circumstances where this arises. So if the intent is let's figure out the definition of motor carrier, that's not what this bill does at all. It eliminates the entire direct action statute. Happy to answer any questions that the committee members have.
Anybody have a question on the committee? Go ahead, Chairman Roberts.
Well, we were with juries to start with. I thought we were out of it, but now we're into motor vehicles. So, Mr. Peak, if and I don't want to go to a specific case, but if a large motor carrier from out of state is involved in a crash here in Georgia, when that crash is investigated, is the name of the insurance company gathered at that point in most cases that you and your firm have to deal with?
Yes, Senator.
Okay. So knowing that the driver of the vehicle and the company that owns the vehicle, whether it be the independent driver, whether it be a large corporation, when you sue them, they have a contractual agreement with the insurance company to cover them when they're wrong or when they cause damage. Is that right?
Yes, Senator.
Okay. So if you sue the company, is it natural that you would include who their carrier is, who the insurance company is in there? Or is there a way for the insurance company to separate themselves from the carrier?
That's an excellent question. Venue has to lie independently where the lawsuit is brought has to lie independently with respect to the insurance company and the motor carrier. So in several instances, this doesn't happen all the time, the insurance company itself is sued without the motor carrier and the driver being sued. And so you're not even forcing the company to have to undergo the process of the lawsuit, and you're limiting the amount of coverage to the available insurance coverage.
Okay. But is there so in that case there, you would only list the insurance company when you filed?
Yes, sir.
You would not list the carrier.
Yes, sir.
But in this case, do you list the carrier and the insurance company, or in the other type cases?
Many times that happens when you are able to obtain venue in the same place, when you can get all of them in the same place.
Right.
And the reason is the documentary evidence, the discovery. There are benefits of having the motor carrier name to get the discovery.
Okay.
Senator Calvert, let's
I'll just close.
quickly close and
I'll just close by saying each of these bills were included in, it was SB 415 initially last year. It might have changed numbers, but it came through this committee and they've passed. I just thought it was simpler to pick some of the more obvious common sense changes as independent bite-sized pieces this year.
all right, thank you. What's the will of the committee? So it's a do pass motion for LC 364658, Senate Bill 191. So here a second. Second from Senator Kirkpatrick. Any further discussion? Hearing none, those in favor of do pass, as the motion stated, please raise your hand and keep them up till we get a count. 1, 2, 3. All right. And those against? 1, 2, 3, 4. Okay, the motion has failed. All right, that's the last order of business we have. This meeting is adjourned. Thank y'all for your patience.